I think we can likely get started then. Welcome everyone to today's webinar. We're thrilled to be joined by Jordan, Rodney, and Humera Rehman from MaxPeople and Rodney Employment Law, one of Employment Hero's trusted partners. Jordan is the Vice President of HR and Legal Services, known for his unique blend of legal expertise and HR insight. A lawyer by training and a people leader by heart, he's a sought-after speaker featured in outlets like the Globe and Mail and HR Professional. Humera joins us and is an employment lawyer and associate at Rodney Employment Law. She advises clients on everything from wrongful dismissals and workplace investigations to compliance and health and safety. She's passionate about providing practical business-focused solutions that help employers succeed. So together, they're going to bring a powerful mix of HR strategy and legal expertise, helping employers build strong, compliant, people-first workplaces. And with that, Jordan and Humera, thanks so much for joining us today, and I will hand it over to you both.
Thank you, Natalie. We're thrilled to be here. I just want to make a couple of preliminary points. I was at a partner event. I had the opportunity to attend an Employment Hero partner event last week, and it was fantastic. So, Employment Hero throws a great party. Second thing I wanted to mention is I see people from all across Canada, which is like super exciting. And I sincerely hope that everyone on the call is a Blue Jay fan and is cheering for our national team because it has been all consuming, certainly in my household. So, oh, go Jays, go! Love it. And then the third thing I wanted to mention is Hamir and I, and with Christina's help, Christina's our training specialist. We've designed this course to be interactive. So we're going to present you with some important content on employment agreements, but we really want this to be, really want to have answer questions throughout and at the end, and we're going to leave about 20 minutes at the end to be able to answer your questions. So please ask questions that you need, and we'll go from there. So initial comments I want to mention before I just ask Kamara my first question is there's a rapidly changing landscape in Canada, in the workplace, as many of you know, in the last few years, whether it be COVID, whether it's returning to the office, whether it's vaccinations. And at the center of that storm has been employment agreements. From our perspective, and I think Camara will share this as well, it's probably the most valuable tool that an employer has in their toolbox is employment agreements. And we're going to talk about how you, if you follow our tips today, you will actually be able to save money for your business, actual real money, and headaches for both you and for employees that are either in your business or joining your business. So, Hamira, as an initial thought, what would your comment be about why agreements are so incredibly important for companies?
Thanks, Jordan. I think I would just echo your sentiments is from a cost benefit analysis, time and time again in dealing with these complicated workplace situations, it comes back to if there was a cost-effective tool that you could have in your toolkit as an HR professional, being able to rely on good, clear, unambiguous employment agreements is always worth it. And so, what I would encourage everyone to do following this seminar is, take a look at the employment agreements that your organizations are using. And if you can even identify some of the issues that we're flagging here today, you would have, gone miles ahead and this would be worth it for you. So very, very important. Can't underscore it.
And maybe we can ask Kamara, like either through the chat or through a reaction, if those on the line today can just give us a quick thumbs up, or check mark as to whether you have updated enforceable agreements in your business. Um, you know, please just show us either through a hand or a thumbs up, because if you do, this is kind of a sharpening the saw, a refresher. And for those that don't, hopefully you will get them in place by November 1st, or realistically by the middle of November. Like you'll have a couple of weeks to do that. So I want to just give you a bit of an introduction about who MaxPeople and Rodney Employment Law are. We years ago, our firm, we've been around 20 years. Years ago, our firm asked the question, why do we exist as a company, as an HR company, as a law firm? And it's very clear that this purpose still withstands time after many years. It's to help people in business be more focused, happy, and productive at work and in life. And I don't think this has ever been more important, Humera, than in the last few years, given what people have had to deal with in their personal life, in their work life. So this very much, we've had this purpose statement for probably, I don't know, 7 or 8 years, but it holds true today as much as it did in the past. And we have four services in our business. One is fractional HR. So for companies that need HR but don't need a certain level of sophisticated HR, but not a full-time HR person, we do a lot of leadership training, which is what Humera and I are doing today. Content and leadership training. We do recruitment. And of course, Humera and I are employment lawyers, and I'm very happy to have Humera with me because she is one of the most technical lawyers and knows a heck of a lot about employment agreements of all kinds. So join our community. We have our Rodney Employment Law LinkedIn and our MaxPeople LinkedIn, our HR company and our law firm. You can get valuable information on blogs, on trends, on further developments. So please feel free to join us. I think someone did ask the question. We are happy to send over the slides via Employment Hero after the session. Natalie will make arrangements to send that out. And just want to cover the three key areas we're going to cover in the next half an hour. We're going to talk about employment agreement must-haves. Humera is going to take the lead on that. Some important elements of employment agreements. I'm going to talk about when you change an employee's status when they're working with you, what that looks like, and what some of the things you should keep in mind. And then Humera and I are going to share the last section on employment agreement pitfalls or things you should be aware of. So without further ado, I'm going to turn it over to Humera to talk about why employment agreements matter. And
Thank
again,
you.
keep the questions coming, please.
First of all, I'm glad that so many participants have employment agreements. That's always great to see. I see that some people are maybe hiring their first employee, so hopefully we'll be able to impress upon them the importance of having updated agreements, ready and able to use. But time and time again, it seems that in a lot of law blogs and things like that, employment agreements are always being challenged and set aside. And so a lot of clients come to me and say, well, why have these employment agreements in the first place, if they're challenged so often? And I say, well, you kind of only hear the bad news. So, well put together employment agreements aren't challenged. They don't make it to the litigation stage. You don't hear about them. They quietly do the jobs that they're supposed to do. And what is it that they do successfully? I think the first thing that a good employment agreement will do is it will provide you with legal protection, obviously. And what I mean by that is that there are certain actions and protections that are only available if both parties, meaning the employer and the employee, have consented to them in an employment agreement. If that has not been done, then there's certain actions that you as an employer cannot take and certain protections that you can't take advantage of. And it's much more difficult to introduce those terms later on. So for the flexibility and the protection that it affords you, I think they matter. And secondly, they provide a high degree of clarity and clarity of expectations if they're done properly. Meaning that I don't, sometimes we see employment agreements, Jordan, I think we reviewed one recently where it was like 20 pages long. The longer the employment agreement doesn't necessarily mean the stronger it is. In fact, sometimes the shorter, more concise, clearer employment agreements do a lot more work for employers. And what I'll say is when you have clarity in terms of compensation, in terms of expectations in role, in terms of obligations, in terms of terms and conditions, those will all lead to a more satisfied employee who is well aware of their rights and obligations. And I think ultimately that leads to greater retention and stability in the workplace. Jordan, would you have anything to add to that?
I think you've covered it. I think the one thing I would say is that it helps professionalize your business. So it makes your business look like it knows what it's doing. I think it's something that's good. Amira, there's already a bunch of questions coming in. I'm going to ask you as we're kind of going along. Do you think all employment agreements need to be reviewed by lawyers? What would your thoughts be on that?
I would say absolutely. And I'll go a step further. They're technical, they might look very simple, some of them, but they need to be reviewed by someone who actually specializes in employment law. Because if you read some of these decisions that come out of courts across the country, it's it's crazy to see how small changes in language can make such an impact in terms of the enforceability of an employment agreement or a termination clause. So they should, I actually think they should be reviewed often just because of how quickly the litigation landscape and the employment law landscape tends to change.
Yeah. So what would you say? We're going to talk about this later, but what would you say? Like once a year? Someone asked a question in the chat. Would you say once a year, once every 18 months?
I
Like
do
what
this
would
with my
be?
clients. I do this with my clients is if we do an employment agreement for you, I will diarize a check-in 12 months from then. And the good news is it doesn't have to be very costly because you've already spent the time and effort to put together a very comprehensive document. A tune-up might just be as simple as a quick review to make sure, yeah, you know what, this aligns with the current best practices, case law, and legislative updates. So I like to do an employment agreement review with my clients personally on an annual basis. And if you put it
Okay.
in your calendar, you're not forgetting it.
Yeah, it's like a tune-up. It's like, some
Exactly.
people take care of their cars, some people don't take care of their cars. Great question here from Anne. Anne, I'm not sure where you're reaching out from, but you're asking about addendums, and we're doing a whole section on addendums to employment agreements. So hold your question because it's a great one and we're going to cover it. Someone also asked Hamer about the difference between an agreement and a contract. I think they're one and the same. I don't think there's any distinction between an employment agreement and an employment contract. So that was a question that was answered. We're moving on here to a real life scenario, Hamera.
Sure. So, we talked about the cost savings. And what I hope to impress upon the slide is the very real practical implications. These are cases that, our firm has seen over the last several months. And so one of the key clauses that's important to include in an employment agreement is the termination clause. What is that? It's what details what the rights and responsibilities are of the employer and the employee upon termination. Now, across Canada, we are governed by either federal or provincial employment standards legislation that sets out the minimums that an employee is owed upon termination. Um, many employment agreements have stipulate that you'll just get whatever the minimums are for that province. Sometimes companies or organizations will want to put in a little bit more and they'll have, we'll give you a formula if someone is terminated. Either of those are good options. What happens is if they're not put together right, or if they're unenforceable or improperly drafted, then the default across Canada is to something called common law reasonable notice. And whereas legislation or formulas are really governed by typically length of service, the common law does not look at just length of service. They'll look at other factors, and we call them Bardell factors. And those Bardell factors include things like the employee's age, the factor in length of service, of course, the character of employment, the compensation of that employee, and try to figure out how long it will take this person realistically to reemploy considering their own circumstances. And courts generously have said that common law is typically much more generous than the statutory minimums in most provinces. And so what we put together is just a sample of what would happen in terms of the cost consequences of an organization in having to terminate one employee. And so let's take the example of this, someone who's 34 years old, has been there for 4.5 years in a managerial role, earning $70,000 a year. In many provinces, that statutory minimum to terminate would be around that 4-week mark. If you have an improperly drafted employment agreement, you might be looking at a demand letter requesting 6 to 8 months of severance. Practically speaking, is that person likely to get that amount? No, but they would get anywhere from 17 to 24 if they decided to pursue this through an employment lawyer. And that's just one employee. You can recognize that if you're a large organization or if you're terminating more than one employee or staff member, then the cost to terminate somebody if you have an unenforceable or improperly drafted employment agreement multiplies significantly. So I hope you see the cost consequences and the benefits of having well-drafted employment agreements just by this example alone.
So, I mean, Humera, just to add to that, if you're looking at the second example of the person who's in their mid 50s, we're talking about, I mean, my math is not that great, but we're talking about a difference of somewhere in the range of like over $30,000 that that person can, that company can be saving for
On
that
one
second
person.
person by having
Yeah,
$30,000 and assuming you have 50 people with an average, we could be talking about, hundreds of thousands of dollars in savings if it's done properly. So I think it's
absolutely.
very significant.
So if we can move this along, I do have a polling question, if we can. So if we can open the poll, Natalie, I'd like to ask the participants listening in today the following question. Which of the following key terms should be included in your employment agreement, in your opinion? We have A, elements of compensation. That would mean exactly what it sounds like. Salary or the rate of pay, bonuses, benefits, things like that. Should those be reflected in an employment agreement or not? A non-disparagement clause, which means a clause which basically prevents employees from making negative or disparaging comments, particularly online. A confidentiality clause protecting the confidential information of an organization, a termination clause, and I hope we get this right, all of us listening in, or all of the above. And maybe we'll give it 30 seconds and then we'll close the poll, Natalie.
I think this question might have been too easy, Humera, just looking at the results so far. So we could
I don't know if
probably,
I can see the results. Can I?
well, I can see them, so we'll
Oh,
share
okay,
the
maybe
results.
interesting. Here we go. Okay, here we go. All of the above. Excellent. On that alone, I think we can say everyone passes this seminar, right, Jordan?
Absolutely.
Okay, excellent.
A plus.
Across the board. Let's move on.
Hamir, I just want to deal with a question because I see a bunch. As we're talking, I'm following along on the chat, and there's this question and idea about signing a release and not signing a release, and I know we're going to talk about that, but I just wanted to touch on um, if you have a contract and you're basically paying out what's in your contract, you never have a release because you're basically the person is owed that money. The only time that you would have a release or ask for a release is if you're giving someone more than outlined in your contract. I've had this argument with clients over the years. They're like, I want a release. And I say to them, you're just giving them what's in the contract, or you're just giving what the law requires, the legislation requires. The only time you would have a release is if you give more. And I do think, and I think, Hamir, you agree with me that it's a good practice for clients to pay a little bit more to get a signed release. But that's a dialogue we have to have with our staff members. So I just want to note that because it's been mentioned a few times that you don't give a release unless you're giving what's more than the contract. Do you
For
agree
sure.
with
I think
that?
we'll just touch on one other question is, what is a little bit more? What would, how much more is a release worth, right? Jordan, I guess it's a question for you, right? Is how do you determine how much more to offer somebody to get a
Yeah.
release?
I look, I think it's a case by case scenario, but there's a comment here from Victoria. My employment lawyer has advised to pay less than the contract but sign a release with extra for the release. I'm not really clear, Victoria, of that question. But the bottom line is if you have a contract that offers ESA, employment standards code minimums upon termination, and you're paying the minimums, you would not ask for release. If you're paying an extra 6 weeks, that's when you'd get a release for those additional amounts. And similarly, as Samara talked about a formula, if you have a formula in your agreement that says, you'll get 2 weeks per year of completed service up to a certain max, because that's more than what the legislation requires, you can ask for a release in that case, but not if you're giving someone what they're legally owed. So we'll come back to this, but let's stick with restrictive covenants now, Humera.
Excellent. So we've talked about termination provisions being one of the key terms to have in an employment agreement. The other key terms, and people are rather surprised to hear this, is you need to bake in what how an employee should be governing themselves before and after the termination of employment or the termination of the employment relationship. There's a wide variety of restrictive covenants that an employer might want to consider, but the key ones that come up again and again, and I strongly recommend considering, are the following. One, a confidentiality provision, something that clearly stipulates how confidential information should be handled. This is particularly true for people who are working remotely, because you just have less oversight on how that confidential information may be managed. A non-disparagement provision. A lot of businesses rely on online feedback and word of mouth, and having a non-disparagement provision that basically says that you won't speak negatively, particularly online, about an organization, will protect an organization from what we see unfortunately happen from time to time when you have a disgruntled employee that leaves a negative Google review or a negative Glassdoor review. And those are much more difficult to deal with on the back end if you don't have a non-disparagement provision to rely on in the employment agreement. One thing that clients come to us and ask about in terms of restrictive covenants is a non-solicitation or a non-compete clause. And I'll quickly cover the difference between the two, and then we can talk about them in some detail. A non-compete is basically exactly what it sounds like, that you're agreeing to not engage in a competitive activity against your former employer. A non-solicit is a little bit nuanced. They're saying, it basically asks, that you will not engage in activities that could seen as compromising or taking away from the business relationship, basically poaching business relationships or staff from your former employer. And I'll say that I tend to discuss non-solicitation clauses much more seriously than non-competes. In Ontario, barring very limited exceptions, non-competes have largely been banned since 2021 as far as our employment standards legislation goes. Non-solicitation clauses are something to seriously consider. And so those are some of the big ones that I would consider including in most employment agreements. And then moving on to, you have an employment agreement. How do you make sure that you can rely on it? What are some key steps that an organization can take once you have drafted a good employment agreement to make sure that it's enforceable? I'll say step one is a pitfall that we see from time to time is miscategorizing contractors who are basically, businesses contracting with other businesses on their own accord, and mischaracterize them as contractors when they ought to have been employees. And we see this all the time. Sometimes you have individual members coming to us and saying, I'd rather be a contractor, I'd rather not be an employee. And while someone's while someone's preference is something that gets considered, that's not really the tool or the test that the courts will look at. And if you are mischaracterizing someone as a contractor when they ought to have been an employee, you are potentially exposing yourself to all of the risks that comes with, frankly, not having an employment contract at all or not having an agreement. And then there's CRA liability, NEI and CPP liability as well. So that's one. The other thing is, not having employees sign on time. Oftentimes, companies engage in a practice where they'll say, oh, we'll have an employment agreement ready for you your first day, sign it then. Or we'll give it to you on your first day, take a few days to look at it and let us know if you have any questions. And to those organizations, I say, you're really, really risking the enforceability of the employment agreement entirely by engaging in that practice. The best practice is when you're going to be hiring someone, have them sign and return the employment agreement well before their first day. And we're not talking the morning of, we're saying give it 3 or 4 days minimum. And so what that means is giving your potential hire the employment agreement to review and sign weeks before the start date if you can, so that they have ample time to review it and come back to you with any questions. So you're not scrambling to get a signed copy before the first day. And then the last thing I will say is a bit nuanced, but a lot of employment agreements have probationary clauses, which basically say something to the effect of, if we let you go during the probationary period, that we don't owe you anything, except for, the wages that might have been accrued in that time period. Basically, that no severance is owing. And I think there's an over-reliance and basically a mischaracterization on probationary clauses as far as that goes, because clients are often surprised to learn that a probationary clause puts employees on notice that that's not indefinite employment perhaps, but what they don't realize is that there's a reverse obligation that a probationary clause imputes, which is to say during this probationary period the organization is committed to assessing the suitability of someone's employment, and if they're not prepared or willing to do that, or they can't show that they've done so, then they might be in breach of their own probationary clause. So sometimes I tell clients this all the time. Maybe if you're not committed to that probationary process, it's a conversation to have of whether to include a probationary clause at all. And there's pros and cons. But those I would say are some of the big issues that I see come up from time to time.
And I think Humera, it's a great summary. I think one of the things I want to mention, you talked about the classification of contractors and employees, and in the middle there's the dependent contractor, someone who is not an independent contractor but not an employee, but whose livelihood is financially dependent on the employer. And there was a big case in Alberta last year, which talked about as a dependent contractor, you're actually entitled to reasonable notice at common law. So, someone could say, I want to be a contractor, but if they're really not a contractor, it's a significant risk to your business. So I just wanted to point that out. So if you do have contractors, reach out to Rodney Employment Law, reach out to your own firm, reach out to someone to really help you with that classification. There's also a question that was asked, and it's from Michael Sherwood. And Michael, if I could answer this question, I'd probably be the wealthiest lawyer in Canada. You've asked the question, you said, if you have an employment agreement that has a good clause on termination, which I'm going to talk about now, why do you need a release? I've had this debate, Michael, for years with clients. They're like, what's the point of having employment agreements with good termination clauses if you want to give, why do you have to give more to get a release? And the short answer, Michael, is you don't. You don't have to give more. But here's my comment to you. Would you rather pay a law firm $10,000 and take valuable time, or would you rather get a release for $7,000? And it might be a different amount of money, but you have to ask yourself, do you want to kind of like, it's a cost benefit analysis, but the difference is if you have that good clause, then you don't have a blindfold on and you know that you could withstand, your contract can withstand scrutiny. If you don't, it's kind of like being blindfolded and you don't know what a court is gonna conclude. So Humera and I talked about this slide here, and this has been the most frequently litigated element of employment agreements in the last few years across Canada. And employment law has really been turned on its head. And the general principle with termination clauses is, I'm simplifying a very complex area of law. It's that if you violate employment standards in your jurisdiction, whether it be Quebec, Nova Scotia, BC, Ontario, then the employment agreement is likely going to be considered to be invalid. And that person will become a common law employee, or in Quebec will be governed under the civil code. So it can be, as Humera mentioned on the earlier slide, very, very costly. So you have to be very careful with your employment agreements. It is the greatest investment that you will make. It could literally save you, I say to clients, by making the investment to have proper employment agreements, 10 to 20 times what it would cost you to not have them. And I know lawyers like to make promises, but that is a genuine promise coming from a genuine lawyer. Okay, so let's talk briefly. We wanna leave a lot of time at the end here for questions, so we're going to We're going to try to wrap up in the next 10 minutes. So there's two types of terminations. There's cause terminations, which for those that know or don't know, it's really a three-step test for just cause. And by the way, Humera and I very strongly believe you can terminate an employee for cause. There's this myth that you can't. Humera, I think you would agree that you can, and we deal with a lot of cause cases. Step one is you ask, what's the nature of the misconduct? Step two, so that if there's no misconduct, there's no cause. Step two is you look at all the circumstances, you look at mitigating factors, you look at how long the person's been there, how serious is it what they did. And then the big question is, can the employment relationship continue? And if not, that's when you would resort to just cause. Um, they've made it a little bit more complicated in Ontario, and not to get overly technical, but there was a case 2 years ago where an employee spanked a male employee spanked a female employee in the cafeteria in front of all the other staff members. Company did an investigation, terminated for cause. The case went to the Court of Appeal, which is the highest court in Ontario, and the court said there's two types of cause. There's cause when you get the ESA minimums. So you do something bad, but you still get the ESA minimums, in this case in Ontario. And then there's cause that is meets the threshold of the employment standards legislation that requires willful misconduct that is deliberate and intentional. So it's a controversial case. It only applies in Ontario, but the only time in Ontario where you can not provide any entitlement is if there's willful or intentional misconduct. That doesn't apply to other provinces, but it's a significant change in Ontario. For a without cause termination, as Humera articulated, if you have an agreement, you could provide the agreement or a little bit more. If you don't, then you have to look at common law factors, civil code in Quebec, age, service, type of job, industry that you're in, compensation, and asking yourself the key question, how likely is it that that person is going to find a job and how long is it going to take them? That's your common law notice period. I don't know, Humera, if you want to add anything, because this is kind of an important section here. Um, Anything you want to add on cause and without cause?
I think the courts have not, unfortunately, provided a high degree of clarity to date. I think that's going to be resolved in the near future. But I think the main takeaway is if you are contemplating terminating somebody for cause, or there's been some serious misconduct in the workplace that you are investigating, that is exactly the time when you want to reach out to an employment lawyer, because cause is very particular. It needs to be done correctly, in terms of documenting it, in terms of making sure you have it, all of that. It's a very nuanced area of employment law.
Okay. So I'm looking, so we have about 20 questions that have come in. So keep the questions coming. We are committed to being done here within 10 minutes because your questions are equally, if not more important than the content. So we're going to move through the balance and then get to your questions. So there was a few questions that were asked about addendums. I think Annie asked a question and asked a question earlier on. There's a lot of times where you're documenting changes. It might be moving part-time to full-time. It might be, fixed term agreements, which Humera is going to talk about. It might be seasonal work. It might be promoting someone. It might be transferring someone from production to distribution, or it might be hourly to salaried. The bottom line is this: you should always document these changes in employment. As far as a new agreement or not a new agreement, if you have a good agreement already in place, like an enforceable agreement, the best practice is to use an addendum just to reflect the changes that you're going to make, whether it's comp, position, etc., and then reference the original contract. If you don't have a contract, an enforceable contract, this might be a time to introduce a new contract, but of course there's nuances to doing that as well. But what I want you to take from this slide is very important that you document changes in employment. We often as employer counsel, we get files. Someone's been there for 17 years and has only their original agreement, but has had 5 jobs in the 17 years. Well, all those different jobs and titles should be captured and documented. And it's not really that difficult to do. It just requires a discipline. So, in terms of leveraging technology and Employment Hero, our valued partner here, a couple of things that can be used for in terms of employment agreements and documents. First of all, it minimizes risk for your business because it's kept it's not an employment folder. It's not in a folder online. It's in a central repository that's confidential, that's secure. You can have different access, different levels of access, one for your senior leaders, one for HR, one for your employees. It gives visibility and transparency to your staff. So it's good for the employer, but it's also really good for employees, which is why this is such a great tool and one that we refer to our clients regularly and also use in our business. So they're not only a partner, but we're also a client of Employment Hero and we use them regularly. So for all these employment changes I'm talking about, this is a great time that you can use Leverage Employment Hero. So I'm going to turn it over to Humera to just kind of wrap up with some of the areas to beware and pitfalls when you're talking about employment agreements.
Absolutely. And we'll go through this briefly because again, we want to leave time for questions. And so one of the things I wanted to caution listeners today on is using fixed term contracts. And I'll only say that they should be used sparingly when you know that person's employment is anticipated to last for, let's say, a year, is the rough rule of thumb that I use. And the risk that fixed term contracts pose for organizations is if you commit to having someone's term of employment be up for a certain length and you need to terminate them earlier than that term, then you run the risk of being liable for the delta if you end up needing to terminate their contract early. So for instance, if you if you provide a fixed term agreement for 12 months to somebody and a month into that 12-month contract, you decide you need to let them go. If you don't have a properly drafted fixed term contract, you might be liable for the other 11 months. The other risk is I see contracts being extended multiple times, time and time again. And at that point, you lose the benefit of the fixed term contract. And in many cases, the courts will revert that employee back to being a common law employee with the same entitlements that they, would have been entitled to in the first slide that we showed with the more generous severance entitlements. If we can move that along, Jordan, to the next slide. I also did want to talk about one key provision that we include in our employment agreements. We include language that provides flexibility to organizations so that they can modify, reporting duties, location, hours of work, things like that. If you don't have language to that effect and you try to unilaterally make a fundamental change to someone's employment agreement to their detriment, you may well have an employee that is legally entitled to treat that contract and that employment as terminated. And if they do so by bringing a constructive dismissal allegation. And so what is a good way to avoid it goes back to having good language in your employment agreement that allows you to make those changes. And so that's a key clause that I would encourage everyone to look for and make sure that they have in their employment agreements. Jordan, if you'd like to move along to the next slide. One way that I've seen constructive dismissals come up recently is these return to office requests that we've had across the board, where people since the pandemic and maybe even prior to have been working remotely for some or all of the time. And now they're being requested to go into the office and they've maybe moved away, they've made lifestyle changes so that they're working remotely as a condition of their employment. And the courts have been increasingly clear on this. If it's been going on for so long that it's a implied term of the employment relationship, then it becomes very difficult to change, except for if you have good language in your employment agreement and you are able to rely on that, or unless you have a good policy where you're giving people advance notice of that upcoming change so that they can modify, so that people can modify their schedules and their lives and accommodations accordingly. And then the last thing that I'll say is if you are an organization that's contemplating a return to office or, modifying the in-office hours or schedule, apart from making sure that you have good employment agreements that allow you to do that, I would also say that make sure you're treating each employee individually because they might have individual accommodations that need to be worked on to allow that return to work to happen. And then I think one of the last things that I'll touch on in terms of employment law pitfalls is layoffs. And one of the key clauses that I include in nearly every employment agreement is a layoff provision that allows you to lay off staff if needed, if there's a business need to do so. The courts are very, very clear, as recent as 2023, as per the Ontario Court of Appeal, that if you don't have an employment agreement that allows you to lay off individuals, then that layoff is a unilateral change amounting to a constructive dismissal, and that employee is entitled to the same rights and entitlements that they would have had they been terminated outright. So definitely, again, same as the constructive dismissal language, make sure that you have layoff language if that's something that's potentially happening in your organization.
And Humera, for this last slide here,
Sure.
I just want to I'll let you kind of add in your thoughts, but I mean, you and I and the other members of our law firm literally get asked this question every week that we want to give new agreements to people that are already working there. Very fundamental distinction between a new hire, someone coming into your business, and someone who's already working there. For an existing staff member, you have to provide consideration, which is something of value to sign the agreement. If you're not employed at the company and you're joining in exchange to sign off, you're getting a job. So you sign off on the agreement. If you're already working there and you're giving someone a salary increase that you've given them 5 of the last 8 years, that's not considered consideration because it's not really something of value. So, very important that when you're giving existing staff updated agreements, that you get legal counsel and legal advice to do that. And again, there's an art to doing that. And I can think of two examples in the last week, one involving about 50 employees and one involving 15 existing staff that we worked on new agreements, and both of these clients said, "Oh, no one's going to care. They're just going to sign off." Well, in the first case, about a third of them said, "There's no way I'm signing." So the question is, what do you do now? And in the latter case, with the 15 staff, 4 of the 15 have refused to sign. So, key point, and maybe you can just wrap up, Humera, before we get to the questions, as to if you have any guidance for companies with existing staff and how to manage that.
Certainly. And it's echoed. I think Miriam chimed in the chat. It's provide consideration if you are if you are updating employment agreements and you can for new hires, that would be something that an employment law firm would be dealing, helping you deal with very specifically to make sure that that you can maximize the chances of employees actually signing off on those updated employment agreements. And
Okay,
what would
wonderful.
consideration be? Mandeep, you've asked. It may well be a signing bonus. It can be anything of value. And ultimately, an employment lawyer will work with you to determine what is appropriate under the circumstances.
Okay, wonderful. So we are at the Q&A stage. We wanted to make sure we have ample time here. We will do our very best. We have a lot of questions. If we don't answer your questions, we will endeavor to do so post the session. But what I'm going to do, Hamir, is I'm just going to read them out, and then I'll either answer them myself or delegate them to you, or if you want to take turns reading them, to whatever works better for you. But I'm just going to start, and so the first question, which I'm going to answer, Hamira, because this one's a fairly quick one. Someone's saying here, I have to be honest, I don't want to hire older employees anymore because of the rules. Um, what I can tell you is obviously, I understand why you're saying that anonymously, that you don't want to hire older people. But again, if you have good agreements and you're buttoned down It really doesn't matter if the person is 27 or 67. But I definitely agree that there's a greater risk when you have older staff because, as a common law factor, the older you are, the more you will be entitled to because it's harder to find a job. So, Hamera, there's a question here about probationary periods. Can you terminate during the 3-month probationary period without a penalty?
So the short answer is maybe. And I hate giving that answer. And it's because it's what I was saying. You need to be able to demonstrate that you gave this person a fair opportunity to prove the suitability of their employment. If you are terminating them because, hey, their performance didn't wasn't up to snuff and you've given them no notice of that and it would be a surprise to them, I would say that you're risking being in violation of your own probationary clause, and which is why many times I actually look at probationary clauses in employment agreements to determine if it's better not to just exclude them, because if you don't include a probationary clause, then you end up in a situation where that person gets what's in their termination clause entirely. Probationary periods are not creatures of the employment standards legislation. They're not included.
Okay, great. Amy asked, it may be difficult to compel employees to sign agreements with updated terms without affecting the working relationship. So, Amy, if you're talking about new hires, you're doing it in exchange for the agreement. If it's an existing staff, I mean, we have a very thorough process that captures both HR and employment law implications. We offer talking points, communication scripts. We've literally done this hundreds of times with clients and, almost always successfully. But you're correct, there is an art to doing it. There's no question about that. And then Hamira, someone asked here, Kathy asked the question, does it matter if some terms such as confidentiality are done as an annual signed form for everyone?
I would say it's not incorrect to have potentially addendums, but you should have language that at least basically outlines those basic expectations in the employment agreement.
Okay, well said, succinctly. Catherine asked, does it mean if you give more and get a release, they cannot take legal action for their common law entitlement? The short answer is, in my 25-year legal career, Catherine, I've seen, I can count on one hand where there's been a signed release and someone has come back and successfully sued. Those two cases were one where the person had significant cognitive issues, or the person was told on the spot, you must sign this release right now. As long as you give people ample time to sign it, once you get a signed release, you're in the clear. Um, okay, Hamir, I'm going to give you this tough question from Lacey. Where can we find the equation to determine an employee's termination based on the Bardell factors? Well, I can tell you where you can't find it, and then I'll let Hamira decide. Don't go on the online calculators because they only provide a framework. But what would your advice be for a company that wants to know the equation, Hamira, which is what we deal
Well,
with multiple times
yeah.
every week?
The short answer is there is no equation. Basically, the courts are looking at Bardell factors to kind of figure out how likely it is for someone to reemploy in a certain period of time. And so there's short-term, short service employees getting lengthy notice periods, and then there's long service employees that, might not get so much more. So if you want to have an understanding of what someone's common law entitlements might be, that's a particular question that I would reach out to an employment lawyer for.
Okay, wonderful. I'm going back and forth with the chat. I made the point, Hamira, on existing staff versus new hires, and that if you regularly, and there has to be some form of consideration or something of value. Someone asked a question. They said, Jordan, can you clarify about the salary increases? The point I'm making is if you are giving new agreements to existing staff and you're giving them something that they typically receive every year, it's not really of value. But if you go to a staff member and you say, I'm going to give you a one-time lump sum payment, or I'm going to give you a new benefits plan, or I'm going to give you 5 additional days off, that could be considered consideration. It doesn't need to be equivalent, but it can't be something that they enjoy every year. And that's a very complex topic. Hamira, next question here. If these agreements are currently not in place, okay, let me skip that one. Someone's asking what exactly is a release? Do you want to take that one,
Sure.
Hamira?
I think we probably should have covered this earlier, but a release is a very comprehensive legal contract, basically saying that as long as the company pays you what the agreed upon amount is, that the employee no longer has the right to sue. And a good comprehensive release would prevent that employee from coming back and suing in any sort of forum relating to their employment. So you're not giving up the right to sue just for the common law notice. You'd be giving up the right to sue for, before the Human Rights Tribunal for human rights issues or discrimination issues or harassment issues or safety issues, really anything to do with their employment. So the benefit of the release is not just saying, I'm not going to get sued as an organization because I might have miscalculated the severance amounts. It's that you can walk away with certainty knowing that as far as the employment relationship goes, that has been settled and ended by virtue of signing the release and paying out the settlement amounts.
Wonderful. Well said, Hamira. So Michelle asked if you offer someone an additional payout on termination and they don't sign the release, are there follow-up steps? Well, the only follow-up step, Michelle, is the way that we set up our letters. And by the way, I've given a QR code on this slide here, both for a complimentary employment agreement review with our firm. And I promise you won't get a bill unless we actually do work on your agreement, but we will tell you, how enforceable it might be. Is it kind of red, orange, or green? And also a QR code for an Employment Hero demo, which I highly recommend. So please feel free to do that. We'd love to help you out. And again, remember, we want to help people be more focused, happy, productive at work and in life. So Scott asks, great Scott, again, if I knew this answer, what's the expression, Amira? If I knew this answer for every time I answer this question, I'd be a millionaire. What are the key points in a good termination clause? Scott, I can tell you that our firm has spent literally hours debating like a single word in a termination clause. Our agreements have been challenged, not successfully to date, as I knock on wood. But we're continuously tweaking and evolving our termination language. It's just simply not something that we can answer in the time that we have. It's a little bit more nuanced, but happy to speak to you. Hamira, in a without cause termination, it's advisable not to provide a reason. Is that correct?
I just don't see the value of it, frankly. Like I've seen employers try to make the case for providing it, but I almost always feel that it does more harm than good. And frankly, there's no legal requirement to provide a reason for the release or for the termination. And so I err on the side of caution and just, I don't get too far into the weeds of it.
Okay. The Court of Appeal case, the decision is Render, Render. So if you type in Render, Ontario Court of Appeal, you could also find a blog on our website, rodneyemploymentlaw.com, but you'll be able to read about that crazy decision. Um, so Hamira, this is a great question. It comes up. Maybe I'll take this one, Amira, because of all the nonprofit work that we do. If an organization cannot avoid fixed term contracts as their nonprofit and the positions are based on funding, great question. We've had this with our nonprofit companies that do depend on funding. You could have fixed term contracts, but at some point we do recommend going to an indefinite agreement with very, very clear language saying that the agreement is largely dependent on funding and that the agreement might be terminated in accordance with the termination provision if the funding is not available. But I appreciate that's a challenging question for those that are dependent on funding. And Mayor, if you have an employment agreement with your employees and you request an updated agreement to be signed, how does that affect the enforceability of the new contract?
It goes back to what we were talking about earlier, right? Is until that new updated employment agreement has been signed with valid consideration, it's the older agreement that is continued to be in force. And so, you have situations that come up from time to time when an employer requests an updated employment agreement be signed. And if the employee elects not to do so, then the older agreement remains in force.
I'm loving the succinctness of the answer, Samara. That's why I'm asking you the question. So, great question from Matt. We had an employee in Alberta take a demotion from manager to non-manager position. What do I include in the addendum? Well, Matt, I'm assuming that this was a voluntary transfer. So you'd basically list what the differences are, and then you'd reference the original employment agreement outside of the changes. If the agreement is not good, now is the time that you could get them on a new agreement. So you'd only give an addendum, you'd only do an addendum if they have a good agreement. Otherwise, it's an opportunity to maybe look at getting them on a new agreement. Okay, so moving along here. Question, what does consideration have to be? Could it be as simple as a $200 movie card if signing is worth several thousand dollars? Well, honestly, I would love a movie card. I'm a big movie fan, and I'm not saying I would sign a new agreement, but that would definitely be of some value to someone. The question you'd have to ask is, what happens if they don't sign? What are you going to do in that case? So, Humera, there's a question here, and again, we will endeavor to go back and answer your questions after because we have about 4 minutes left. Um, so, question here from Tracy Humera. Can you clarify oh, sorry, thank you, Miriam. My trusted partner answered the question for me. That's very lovely. Okay, so question here, Humera. If there's misconduct, this is a question about termination for cause. If there's misconduct but cannot be justified for cause, are we safer to terminate them without cause if their contract ends in a month?
Well, I think that those are two different issues, right? One is like if you don't have cause, you don't have cause. And I think you would have to tread very carefully in determining that. But if it sounds like someone's on a bit of a fixed term agreement where their contract's ending, you will have to make a determination as an organization what's better to do. So I think that's a very specific question, and I would encourage that person to reach out directly, and we'll have a conversation about what might be practical under the circumstances.
Okay, so this is a great question and something that we deal with all the time, Amira. How are separate employment handbooks connected to employment agreements, how to handle policies and procedures in the handbook? And by the way, I've been given permission to go 5 minutes over. So if anyone wants to stay on, we're going to continue going through the questions. So the bottom line here is this: an employment agreement trumps an employment policy. Agreement trumps a policy. Humera and I feel very strongly you should not prescribe policies in your employment agreement because they're going to change over time. So we have an amazing catch-all clause in our employment agreements, our customized agreements that allow us to have our clients introduce new policies from time to time and that you're governed by those policies if you're employed by the company. So the worst thing you can do is include specific policies in your employment agreement. You want to keep it flexible to be able to change it over time. Is there an expiry date on the release, Humera?
No, a well-drafted release is binding forever, and I use that word rarely, but it is.
Okay. Humera, do you recommend a different employment agreement for each province? I know you've dealt with this regularly. How would you advise on that?
It for most every province has their own employment standards legislation, which will govern what employment laws apply to it. What I tell clients to do is if you have an employee that's performing work in another province, or if they're living in another province because they're working remotely, then you should double check and make sure that you have an employment agreement for the province and the legislation that would apply for that particular employee. It's not the case, and sometimes clients are surprised by this, that because your head office is located in Ontario, that you give everyone an Ontario agreement. You might be compromising your employment agreements in that event.
Okay. I'm just going to take two quick ones here, Hamira. Does an addendum need to be signed off by an employee? I would say yes. My quick answer to that is yes. It's a legal document, so it should be. Should a job description be included in your agreement? Again, similar to policies, I think you want to maintain flexibility. So I think you say in the agreement that the objectives and duties can change from time to time, and you provide a job description or job profile separate and apart from the employment agreement. Do you have to give notice of the end of employment if the employee is hired on a fixed term contract?
I can take that question. I strongly suggest it. Do you need to? Not necessarily. But you should definitely put the employee on notice prior to the end of the contract that the contract is coming to an end.
Okay. Uh, Great question here from Lori Gregg. Does the final release need to be signed in ink or will an email copy do? We do, I would say, given this remote hybrid world, we probably do 75% of our releases electronically. There's no issue with that. There might be the older legal counsel who might say it needs to be signed, but electronically is fine. Amir, I'm just going through questions that maybe we haven't gotten to yet. Um, So if a current full-time employee applies for a part-time position that previously had benefits, but the benefits are removed when that part-time position is posted, would this violate the existing employment agreement? That's a really hard question to answer. I think it depends on the specific facts of the case. So if that individual wants to reach out to us directly, I can certainly guide you on that. I'm going to take three more questions here, Hamira. One of our senior employees from Jesse refused to sign the new employment agreement due to the unsatisfactory salary increase. What should be done in this case? So, what happens, Hamira, if the existing senior staff member just doesn't want to sign the new agreement?
Well, there's a whole host of options that you have available. There's a very famous case called Roncos that's out there that speaks to this particular point. But I think the practical element is you can't force them to do so. I've had great luck in those cases in negotiating with an employee because typically it's worth it to get an updated employment agreement in those circumstances. And you can be flexible in certain ways to get them to sign an employment agreement. Maybe the salary increase isn't going to get it done, but perhaps having a preferred formula that would apply on termination coupled with the salary increase might. And so you have to demonstrate a fair amount of flexibility. And other than that, we can talk about, giving that employee particularly, potentially giving them notice in alignment with their common law entitlement and saying, X number of months or years from now, the current employment agreement that you're on is going to come to an end, and there is an offer of fresh employment available to you on substantially similar terms, but this is the updated agreement that will apply. But that's a very nuanced question. Again, it's something that's best addressed with an employment lawyer that's familiar with your specific situation.
Okay, last two questions, Samira. I'm going to take this one and I'll give you the last one. Nola, this is a great question. What if the new agreement has better terms? The new one has a better severance amount. So you're basically we like to call this an enhanced termination clause. And we do this all the time. This would be highly recommended for someone who's maybe been with you a long time, maybe an older staff, like a more senior staff member. And you can certainly provide an enhanced termination clause as an example of consideration. So definitely great question, something we deal with all the time. And last question, Amira, I'm going to give you this one. How about terminating employees who are over the age of retirement? By the way, retirement is illegal in Canada, with the exception of collective agreements and/or partnership agreements. The Supreme Court deemed it to be illegal as of 2001 or 2012, 2012. So I wouldn't even use the word retirement in your workplaces because it's actually illegal. But the question here is, oh, Christina, you just got rid of that question, but I haven't So the question is, how do you deal with, Humera? This is a hard question to wrap up here. How do you deal with a 25-year employee as they're approaching retirement upon termination? I'll let you answer that last question. Uh, we'll get back to the other questions, and I'll just let you answer that and then turn it back to Natalie for any final thoughts.
Sure. I'll say this, when you're terminating someone who's long service, there's opportunities that you have to give them working notice, or pay in lieu, or a combination. So oftentimes in those circumstances, those are elements of structuring a termination that I'm looking at. There's also this, because we're talking with a more senior employee, one thing that I caution employers on is, the entire point of notice is to bridge someone from one employment relationship to the next. Courts have been increasingly clear to say that if someone's past the traditional retirement age, then there's less of an obligation on them to look for another job. And so I say tread very carefully in terms of how you structure. And I always say, it might not be a bad idea to have conversations with that particular employee on how to structure, the end of their relationship with the organization. So oftentimes those are the relationships where some back and forth and dialogue between the two parties results in a very mutually agreeable parting. And then I'll turn it over to you, Jordan.
And I will turn it over to Natalie. And Natalie and Employment Hero, thank you for having us, and thanks for the additional 7 minutes. We needed it.
Absolutely. Tons of engagement and questions, which is really great to see. Thank you so much, everyone, for joining. Slides and recording will be provided shortly. Have a great afternoon.